Professor Pierce, who is a professor of EU law and human rights at Royal Holloway, University of London. And I want to immediately give the floor to you, Steve, for your concluding lecture. Thank you.
Well, thank you very much, and thank you for inviting me. Now, if I click present now, does that get me into my slides?
I think it should.
It should. Okay, I'm just, I have too many things open, so I'm just trying to figure out where they are. Now that seems to, sorry, that seems to show me my internet tabs, not my slides. So what's the best way to share my slides?
Through the present now button, you should be able to share your screen.
My slides, that's quite frustrating. I'll try again. Okay.
Looking at Marcella also and Martina, maybe you have more specific indications?
Yeah, in the bottom below, the bar below, there is a button between the smile and the hand.
Between the smile and the hand, yes. It's not showing me.
Presenta ora.
I have to, I mean, very strange. I don't understand why it's
You have to click on the button.
Yes, I'm doing that, and it's not showing me my slides.
And no, but then you
here we go. Oh, okay, Windows, right, okay.
Okay.
Right, that should work. Okay, brilliant. All right, here we go. I hope. Can you see it now or not?
Yes.
Yes, it is loading. Just yes.
Okay.
It's loading now.
Very good. So I will change the view and go back to the beginning. All right. So thank you very much for inviting me. I've tried to distill together what I think are the main issues in the EU Asylum Pact. And I wasn't able to join you yesterday because I was lecturing for many hours and I had to miss part of today. So, but I know you have covered some of these issues in the context of particular presentations, but maybe not all of them. And I'll try and bring some of what are the main issues, I think, together. Of course, the case law can end up surprising us, and it may be that some of these issues are less important and some others turn out to be more important. And I've tried to be selective anyway, in terms of the issues which I think judges may, at the national level, may in particular have to examine as a consequence of the Asylum Pact. So here's the Asylum Pact. Of course, I assume we're familiar all with the this list of legislation. I won't be mentioning Eurodac because that rarely gets litigated. I won't mention the crisis regulation because that is hard to predict, although I think if it is used, it could be litigated. And I won't mention, although I think it may be relevant, the Commission's communication suggesting that member states can simply stop unilaterally dealing with asylum applications in crisis cases, which is not what the crisis regulation says. It is much more limited derogation subject to approval of the Council. And suffice it to say that I think the Commission's interpretation is unfounded, and Poland or any other countries that seek to stop dealing with asylum applications on these grounds should be successfully challenged via the national courts to the Court of Justice. But who knows if that's correct? But I think it seems fairly obvious that in light of the Human Rights Court case law and CJEU case law, that isn't a well-founded interpretation. The timing of the pact, but just to remind us that it doesn't apply mostly until we get applications from June or July of 2026, although there'll be some implementing measures beforehand. Other legislation remains in force, Temporary Protection Directive, not amended, the Returns Directive not amended, but closely connected to a lot of the Asylum Pact changes, so those connections are quite relevant. The Borders Code is already amended and has some texts from the crisis regulation within it. So anyone dealing with instrumentalization cases, that definition there and how it applies potentially to limiting applications at the border, and whether it does or not, is already an issue that a national court could have to deal with and ask the Court of Justice about. And now there are other proposals on the table, of which I'll only mention the top one there, the most relevant one, to amend the Returns Directive. And as many of us will know, the Commission has already given up on that, but it's going to make a fresh proposal. It's scheduled for March the 11th. Now, from a judicial point of view, of course, a proposal is just politics. You want to wait and see what happens with it and see whether it gets adopted and what it says. But it is very likely, I think, to get proposed, get adopted in some form, and make some changes that would partly be relevant to the links to asylum law, which the Asylum Pact already makes. And it may not be for a couple of years that all has effect, but it could be that part of the changes take the form of a regulation, as with the Asylum Pact, that might then have an earlier date of application. We'll have to see how that works. Now, in general, one thing to keep in mind, and it may be relevant to the overall judicial application, interpretation of the Asylum Pact, is that there's more harmonization than there is at the moment. 2 directives replaced by regulations. Those are no longer minimum standards directives. It's now meant to be fully harmonized. And of course, that may raise questions for how national courts may come to interpret it. You can't fall back on the cases where there may be higher levels of protection. It's perhaps fairly rare for asylum seekers that member states want to have higher levels of protection, but it's no longer an issue. It's not, national law is meant to be replaced by regulations, and there are more details in all of the legislation than there is in the current version of the law about how the EU harmonizes this area. Now, the screening regulation, which was just mentioned several times, one thing to point out that although it may be that a lot of asylum seekers will end up subject to the screening regulation and immediately afterwards subject to borders procedures under the procedures regulation, these are still 2 separate things. And there's, in particular, a different definition of who can be covered by each. So this is the definition of the screening regulation coverage, essentially any unlawful or would-be unlawful entrants, or people unlawfully staying, or people subject to a search and rescue. Now, the borders procedure also applies to unlawful entrants, but subject to some exclusions and subject to certain types of procedure potentially applying in the procedures regulation. So it's not necessarily identical people, and the various rules relating to them are different. So it's not all one thing. It might seem that way to an asylum seeker, but it isn't all one thing, and the legal questions aren't the same, I think, as a result. So there is this 7-day time limit, which is absolute. There's no provision for extension. Who knows what member states might try and do, but it's clear enough from the law that there's a 7-day limit. And the logic is to do some essential checks, put names in databases, fingerprint people, and so on. It isn't a period which is meant to be used to decide on an asylum claim. The borders procedure is that, but the screening regulation procedure is not. Nor is it a period to make a decision on expulsion. It is potentially a time when you're meant to be filtered towards one or the other. You can make an asylum application and start the asylum process there, but the logic is it would be finished and assessed during probably the borders procedure subsequently. Now, one thing these 2 procedures have in common is you can't regard the people concerned as entering the territory, even though people may even be inside the territory in both cases and authorized to attend court and so on. They are not, legally speaking, on the territory. So an immense legal fiction has to be created and sustained according to the rules. And that immense legal fiction arguably has consequences, because when the borders procedure and the screening regulation cross-refer to other legislation, especially the reception directive only applies to people on the territory. So if we're talking about people who aren't legally on the territory, why would the reception directive apply to them? So it wouldn't normally. So you've got to maybe make a jump and make an assumption that why would they include these cross-references unless the drafters of the legislation intended that at least some of the rules in the reception directive would apply to people who hadn't been legally authorized to enter the territory. So it's in a way an extension of the scope of the reception directive to cover those people who are subject to this legal fiction. And that, of course, perhaps raises issues not only for detention, but health and subsistence and so on as well. So what about detention, which I was just asked about? Well, I just mentioned the point there in grey about the scope of application. Now, the preamble, the next point in yellow, does say to the screening regulation that the reception rules on detention should apply. Now, the way I read it, again, answering the question I was just asked, is that this could be seen as a procedure to enter the territory, and that it's an ECHR argument for detention, because, of course, that is one of the grounds to detain under the ECHR. So that might be the argument that member states would make as a ground to detain. And then the question is that compatible with the reception conditions directive? I mean, this is more directly dealt with for the borders procedure, but it isn't very well dealt with under the screening regulation, although the obvious assumption is that people may be detained during that period. What about human rights? Well, there's a general non-refoulement obligation. There's an obligation to investigate allegations of failure to respect human rights. All of this is also copied by cross-reference into the borders procedure. And in that sense, it's new that this is monitoring requirement. And this is meant to be an independent mechanism ensuring that allegations of human rights procedures are dealt with effectively. That may mean, you could argue, some sort of judicial intervention by the independent monitors, or at least that their decisions might be taken into account, or recommendations might be taken into account as part of the judicial process, that may be, let's say, part of a judicial review of detention. So this is a new issue, at least at EU law level. There may, of course, be national versions of it, but this is a new requirement in EU law that in those two areas is something that I think a representative of the asylum seekers may want to raise, and of course the government will try and defend it, say this is weak, but it doesn't, on the face of it, it isn't that weak. It's meant to have some practical effect of monitoring human rights protection. All right, the resettlement regulation, I don't need to mention much, because as significant as it will be for anyone who's resettled, it doesn't really create rights. It's one of several parts of the Asylum Pact where the intention is deliberately to limit the rights of the people concerned. Now, that doesn't apply to the whole pact. There's still some areas where there's definitely still rights, but it does apply to the resettlement regulation as a whole. There's no right to be admitted or request to be admitted. No obligation on member states either. Anything they contribute to resettlement, humanitarian admission, and all the details, if they do contribute, of where they're taking people from and so on, is wholly voluntary. So it is quite difficult to see how the process gets to court. It may, of course, get to court if someone's admitted and then there's an argument to revoke their refugee status and so on, because the qualification regulation, which I won't talk about either as well today, as interesting the changes are there, the qualification regulation will then apply to anyone who's admitted. So, revocation of status and so on would be an issue to be litigated. All right, what about Dublin, or the AAMR, as we may end up having to refer to it? Well, what it first of all revises the existing rules on responsibility for applications and the transfer process, including procedural rights, and it adds rules on solidarity and migration management. So I've picked out the points which may be most relevant to judges, one of which I think is the issue of punishment for non-compliance. As we know, under the current rules, the Court of Justice says you can't punish people for not complying with the Dublin rules, either in terms of loss of employment access or loss of benefits. The new system says, well, you can take certain reception conditions away, if you inform the asylum seeker and if you still give them a basic standard of living. So there may be an issue as exactly what that is. You can't entirely remove their benefits that they might receive. Now, oddly, Dublin, although not to the directive, sets out exceptions to this new rule. So you can't take away the reception conditions if you have reasonable grounds to believe the asylum seeker is a victim of human trafficking, in a directive which has now also been amended around the same time. So there could be, in that context, arguments over whether the asylum seeker is, in fact, a victim of human trafficking. They would want to argue that, of course, to retain the full benefits. Not generous benefits, but still more generous than the basics they would receive as this punishment. So trafficking arises in that context. It's already been in a few Dublin cases. It will arise very explicitly in that context. And there's also a general obligation, incredibly vague, so the sort of thing judges might get stuck with interpreting, to take into account the individual circumstances of the applicant, including violations of fundamental rights in the member state where they're required to be present. So that sort of crosses over with the question of potentially still not having to apply in a member state where human rights breaches exist for asylum seekers. That human rights clause is retained in the new regulation that goes back to the case law of the two European courts. But it does seem to be a specific point in relation to punishment, as well as being a ground related to responsibility for applications as such. And how that might interrelate and what it might mean, I think, is something that may well come before judges under the new system. Next, what about procedural rights? Well, they've revised some provisions on interviews and information and children. There's a new right to a legal counsellor. But fundamentally, the remedies you get as an asylum seeker are curtailed. There's no longer a general right to challenge a transfer decision. It's only where the existing case law has referred to charter rights that the drafters have assumed they can't remove judicial review in those cases, but they have assumed they can remove them in other cases. So what remains is a judicial review right in respect of Article 4 charter issues, so collapse of asylum systems, decisive circumstances since the transfer decision, or an infringement of the rules on family links, which have been amended, widened slightly. You could argue about those because the case law says they're charter issues. But all the other grounds that people have argued about, and the Court of Justice has ruled on a number of them, you can no longer argue about. Well, in principle, this means less work for judges. They shouldn't be hearing these cases at all. They shouldn't be asking the Court of Justice at all. Of course, the argument might be that this is an infringement of an Article 47 effective remedy point. The difficulty in making that argument is there was a Court of Justice judgment just before the Dublin III regulation that said that judicial review under the earlier version of a transfer decision could be very weak. That's an incredibly badly reasoned judgment with respect to the Court of Justice. But of course, I imagine member states may be thinking they can revert to it. It is, the Abdullahi case, it is something that the Court of Justice, of course, decided. Now, one thing across the Asylum Pact is there are lots of time limits. There were a few before, and in the current law, there's lots more new time limits. I won't mention all of them, but one of them is, a lot of them do relate to the judicial process. And one of them here is that there must be 1 to 3 weeks to bring an appeal. And also where you do have an appeal right, where the deadline only matters and the rights related to appeal only matters where you do have an appeal right, it's now a weaker prospect of staying on the territory of suspensive effect while the appeal right is exercised. So the main rule is now simply requesting suspensive effect. As one of the speakers said earlier, there may still be a lot of cases where judges choose to grant it this request, but it's a weaker prospect of staying on the territory than before. Now, what about detention in the Dublin context? You still can't detain someone purely for being subject to Dublin, but the threshold to detain them is lower. It's any risk of absconding, not just a significant risk of absconding. Now, I don't know how much that single word added in practice to judicial review threshold assessment, but it's gone. And there's a new second round to detain where the protection of national security or public order requires. It's similar to grounds under the reception directive that the Court of Justice has already interpreted fairly strictly. I can imagine member states arguing that it's not so strict here, but that is an argument that I think is likely to be used in some cases to justify detention, and of course would then be judicially reviewed. Now, judicial review of detention isn't removed, even though judicial review of the transfer is limited. Review of detention is not. So a lot of the existing rules are retained, such as being as short as period as possible. Some of the time limits on detention are shortened, partly because the transfer time limits are shortened as well. So keep that in mind. Certainly, states shouldn't be detaining people after those time limits. They are written in a fairly strict way. There are time limits for Dublin detention, even though there aren't for asylum detention in general. Otherwise, different ones for the border procedure. But keep that in mind as compared to other grounds for detaining asylum seekers. Next, what about detention conditions? Well, there's mostly a cross-reference to the reception directive as before, which has been amended, but there's some of the texts, some guarantees have been added into the Dublin text. So you've got this overlap that might be confusing in practice. So still, you have to look at issues like proportionality, alternative mechanisms, and so on. Now, I won't go through in detail the process of quotas or financial assistance. One key question here is whether it's voluntary or not. It seems obvious to me that it is voluntary for member states to accept quotas of asylum seekers from other member states. The word voluntary is in the preamble. But Mrs. Le Pen's party has gone to the Court of Justice to say that the whole regulation is invalid because it's not voluntary. And I guess the Court of Justice may well answer that question even before the Asylum Pact becomes applicable or shortly afterwards. We should have some clarification of that. I mention it here only because if it is used in practice, certainly if it is mandatory, I can imagine some of the very complex rules on it potentially being disputed in the national courts, as well as being an incredibly difficult political argument, which they've scheduled to have every year. At the end of every year, there'll be some immense arguments between member states on the solidarity process. Right, now, reception conditions. There are some issues about travel documents. It was already mentioned that there are some detailed rules which I think are vague and ambiguous, likely to be litigated, about limiting asylum seekers to stay in a particular place. Now, detention, as we heard, some of the same rules are there, about some of them are new, and some of them are amended. The definition of detention you've already heard about, that remains the same. What sort of things remain? Well, you can't detain someone just for applying for asylum. There's a new rule: you can't detain someone purely on the grounds of nationality. You still need an individual assessment. It's added that it can't be punitive. There are some new rules on special cases where I can imagine this would come up in judicial review. There's a lot of ambiguity on this. Who's a special case? You might possibly be released from detention or have different detention because of your personal circumstances. Well, I imagine the lawyers would often argue these points and judges having to decide them as a new issue. Obviously, the existing case law doesn't give us too much guidance there. So it's still an exhaustive list of grounds for detention, and detaining on criminal law grounds, stabbing someone and so on, is still going to be outside of the scope and a purely national criminal law issue. So what are those grounds? What's new? Well, there's a new risk of absconding, which I think is the same as the returns directive. Although one thing the Commission tried to do with the returns directive 6 years ago was to have a much longer list of risks of absconding, an almost limitless list. That hasn't happened here. It's a more narrow concept of risk of absconding, and that may not change practice much, but we have it there. It might be relevant to, of course, arguments over whether that risk exists. Now, the new ground for detention is to comply with obligations about staying in a particular place, that link to the new obligation to stay in a particular place, that, as I say, is quite vague and uncertain. But what's relevant about it from a detention point of view is that if you don't comply with these vague obligations and there's a risk of absconding, then you can justify detaining someone as a member state. So that's a new one that judges, I imagine, will have to deal with in judicial review cases. So there's an amended point. It's no longer a reference to entering the territory in general, but a reference to the Borders Procedures rules in the Asylum Procedures Regulation. So in effect, you can challenge whether you should be in the border procedure by challenging whether you're detained, given that people in the borders procedure, I expect, will often be detained. That will be a means of challenging not only their detention, but in a way, whether they should be in that procedure at all. In any event, the link has already been made in the case law between borders detention and this ground of detention in the reception directive. Now, there's existing ground if someone is detained under the returns directive or national security public order, Dublin detention. We've already seen that that's changed. What about detention safeguards? There's still no general time limits for detention as a whole. As I said, though, for the borders detention, the case law says the time limit for borders detention is a time limit for detention on the grounds of the borders process. So presumably, even though the grounds and time limit for the borders process are different, the same logic still applies. Once the time limit's up or the grounds don't apply, you must no longer be detained on that basis. You can, of course, as a member state, try and detain someone on a different basis, but you can't detain them anymore on that basis if presumably that case law is adapted to the new scenario. There's a stronger giving reasons requirement that, of course, will perhaps be relevant to judicial review if the argument is the inadequacy of the reasons. The authorities may go back and then give better reasons, but try and detain on that basis. But in principle, the starting point is you must give more reasons. And there's now a time limit on judicial review. I mean, this sounds very long from what a comparison with the Italian context of very strict time limit there. But for some member states, it might be relevant. The judges have to decide within 15 days or a maximum of 21, and people must be released if there's no judicial review by that date. It may be unambitious compared to member states' rules, but that is what the directive now says. And there are some new rules on detention conditions. The drafting of this was during Trump's first term, and the European Parliament particularly insisted on various rules about not separating children, obviously looking across the Atlantic to his previous behavior. So that could be relevant to some cases of family-related detention and what some member states may want to do to be particularly severe if they feel inspired by Mr. Trump. Well, there are limits there that should be enforced. Not a complete ban on detaining children, but certainly limits on the way in which they're detained. Right, now I've selected a few issues from the Asylum Procedures Regulation. One of them, which is going to be relevant, I think, to the appeals process, and we'll come back to the link, is that there must be a link, and many member states already do this, but there must be a link to return decisions, between return decisions and rejection of asylum applications. You must simultaneously, if you reject the asylum application, you must simultaneously issue a return decision, or issue them both as part of the same decision, which means that the appeal of the two is linked in some way. There were also some changes to the rules on withdrawals of applications, much stricter than they are under the current law, and I can imagine member states being enthusiastic about using them. So these will be quite new issues to come before national courts about implied and express withdrawals. You'll see I think, a lot more examples of member states saying that there's an implied or express withdrawal of an application, and more asylum seekers saying, well, hold on, I didn't actually withdraw. So that will have to be going to court more often, I imagine. Now, borders procedures you've already heard about from some of the other speakers. It's quite a significant change. It's mandatory instead of optional. Most member states are doing it already. It is now mandatory. There are specific numbers, as you heard about, that member states are supposed to apply it to. You have a much longer time limit. There are still some exclusions from its scope, and I imagine that they may well be litigated as well. Some of them are vague, like vulnerable people are meant to be excluded from its scope. Well, who are they? When do you apply those rules to individual cases? That is, of course, I think something which I think is going to be the subject of legal challenge, especially given far more people being covered by these rules potentially. Now, as for the rules on detention, the regulation says the reception condition rules apply. So even though someone isn't legally on the territory, again, that sort of awkwardness about the scope of the reception directive, the regulation directly says that the detention rules in the reception conditions directive apply. It also directly says that the rules on procedures apply that are in the rest of the procedures regulation, including the right to stay on the territory. Well, how do you have the right to stay on the territory if legally you're not on the territory, even though that's only a legal fiction? Well, and presumably, we adapt that right to stay on the territory to be a right to stay in the de facto territory of a member state, even though it's not de jure on the territory of a member state. And that seems to me the only way you could deal with that cross-reference. Of course, it's quite important because if you don't have a right to stay on the de facto territory, the member state could just say, we're removing you, and there'd be no recourse against it. But the whole logic of the way the borders procedures works is that it is meant to be integrated into and a fast-track form of the whole asylum process, which is not meant to have you removed, before a decision is taken. A first instance decision is taken at the very earliest, with a handful of exceptions from that. Okay, there are deadlines here as well, 5 days to lodge an application, but a 12-week deadline to decide. Now, unlike a whole bunch of other deadlines that are added to and elaborated upon in the procedures regulation, the 12-week deadline on borders procedures is not only for the administration, it is also for appeals. So it's the combination of the administrative phase, the civil servants have to deal with, and a time limit for judges. So if someone appeals a refusal, whatever's left of the 12 weeks is in principle the time that you, as a judge, are going to have to decide this appeal. Now, maybe they'll make a decision very quickly. You've got 11 weeks to decide it, or maybe they won't. You'll have 5 or 3 or 2 weeks to decide the appeal. Now, the context of that, however, there's a huge qualification here, because the case law on the current directive says that any deadlines that member states give to judges aren't real. Right? My students would love this. Anytime I have to write an article, or I would love this. Right? Getting to a train. I'd love it if it's not a real deadline. But the case law says it's not a real deadline for judges. And if they miss the deadlines under the current directive, well, nothing happens. They just have to still try and give the judgment as soon as possible. So does that apply to the borders procedure? Because under the borders procedure, if they miss the deadline, in principle, something does happen. Once you get past that deadline, the case law tells us you have to release the person, and they're no longer subject to the legal fiction of non-entry onto the territory. So the border procedure is over. You'd have to detain on the ground and go into the regular process. So that is a profound change, given a profound qualification on the deadlines for the judges that in theory exist. What does that mean in practice? That I think is going to be quite significant. It may well be that judges make some effort to meet the deadline because they may be sanctioned or whatever if they don't. But that I think is a crucial point. Now, there's a borders return procedure regulation, which raises a lot of the same sorts of questions. If you've been rejected, the member state has an extra chunk of time to go through a returns process. And there are other issues of detention related to that. Now, this is brand new. It's set out in a separate regulation. There could, of course, be a whole series of issues related to this. I won't have time, I think, to go through them all. I'll have to be a little bit quicker looking at the remainder of this text. I want to leave a little bit of time for questions. So the accelerated procedures, how is this relevant to judges? Well, at the moment, the various accelerated procedures aren't mandatory. So member states aren't all applying all of them. Now, in the regulation, they will all be mandatory. So some of them you may not have seen as a judge because the member state may not be using them. Well, they have to be using all of them in future. And they may not bother with some of them often, but some of them perhaps they will use more often, given that they are required to do so. And I won't go through them all, but there's a couple are amended and a couple are new. And in the green, if you can read it down towards the bottom, one of the new ones is where there's a low recognition rate, which they define as 20% or below, unless there's a significant change in that country, or the asylum seekers in a category which is may have greater protection needs, looking also at first instance and final decisions, at the success of appeal rates, itself a judicial issue, of course, that may be relevant. So that is a new one. The others are maybe relevant for the first time in some countries, but that and the one before it in blue is another new ground for accelerated procedures that we'll have to deal with for the first time. So, of course, people will be arguing that there is a significant change, or that they are in a category of people for whom the low recognition rate is unrepresentative. They're, gay applicants or from various ethnic groups or so on who may face higher degrees of persecution. Now, the national authority may bump people into the ordinary procedure. Only some of these grounds can apply to unaccompanied minors. Arguably, it's optional, the other grounds for unaccompanied minors. And again, there's a whacking huge exception for vulnerable persons to all the accelerated procedures. And I imagine, again, as with all the various other exceptions for vulnerable persons, it's often going to be argued that this particular applicant is vulnerable and can't be in that procedure. Now, safe countries there are major changes to these various concepts of safe countries. We've heard about safe countries of origin earlier today, but to summarize, safe third country now is defined more broadly. It won't have to be a country which ratified the Refugee Convention, but there will still have to be some basic degree of protection in that country. So you still have to be protected, against refoulement there and have effective protection there. However, it will now be possible for both safe third country and safe country of origin to exempt parts of the country. So Italy can revert to some of the things it was doing in relation to the Italy-Albania scheme in future. You can also exempt certain groups of people. One of the points that's being litigated in respect of the Italy-Albania scheme is whether you can do that for safe countries of origin. You definitely can do it under the Asylum Pact for future applicants. For safe third country, although not safe country of origin, for safe third country, you can even exclude individuals and say the authorities can say, we're absolutely certain you in particular would be safe in that third country. It seems an extraordinary thing to do by legislation of some sort that assumes the outcome of the individual challenge to that determination and is incompatible with the idea of having an individual challenge, which is retained, but nevertheless, it is something which the law now provides for. Now, as I said, you can still challenge these applications individually, whether it's safe or whether you have a connection. So the requirement of a connection with that country is retained. You can't send, Afghans who traveled through Iran and Turkey to Rwanda, what's the connection with Rwanda, for instance? And the preamble gives some indication of what is a connection, such as family members or settling or staying. It doesn't say anything about mere transit. Of course, it doesn't say anything about Rwanda scenarios, where the asylum seekers never been within 2,000 miles of. However, in the middle, or at the bottom of the next slide, there is an early review of the safe third country rule as a sort of political compromise, knowing that the composition of the European Parliament would change. That is reviewed by the middle of this year, so a few months from now already, may even be brought forward. But again, as judges, you have to wait for that legislative process. I think there's almost certain to be an attempt to amend the legislation to weaken or remove the connection requirement, and perhaps maybe change some other things too. You have to wait to see what results from that, and before we could discuss how it might be interpreted. But that is coming down the line. And another thing that's coming down the line is possible agreements with non-EU countries to consider them safe, rather like the UK-Rwanda agreement, or Denmark and Israel had agreements with Rwanda as well. Not quite Italy-Albania, because of course that's it is an Albania that's fully dealing with the applications, and it's quite different from this. But it is more like the UK-Rwanda deal. So who knows if the EU will negotiate with those countries. The important point to point out is that the Council's decision to conclude those treaties can be challenged in national courts. Like the validity of any EU secondary measure, it can be challenged in national courts. National courts, if they think it might be invalid, have to suspend the case and send questions on the validity to the Court of Justice. We don't hear much about this happening. It's only happened once or twice in asylum cases before, but it perhaps will be happening more often. And this is an example of where it may apply. And the other example of where it may apply is where there will be potentially common lists at EU level in future of safe third countries and safe countries of origin. So we've heard a discussion of whether you can challenge a national determination of a safe country. How much judicial review of that? Well, of course, the issue will be broader. It will be how does the judicial review of the EU's determination to put a country on the common list and keep it on the common list, perhaps there's a failure to act issue of not removing it, arguably. How much can that be reviewed? Again, the validity of any EU law which sets out a common list can be the subject of a challenge in national court. The national court would have to send questions, if it has reasonable doubts about the validity, to the Court of Justice. It can't determine that issue itself. It can issue interim measures. It can't determine itself whether the EU law is invalid. But of course, interesting questions. There's some interesting questions of how that relates to national lists as well. You can have them, but if the EU took a country off its own list, the member state can't put it on its national list for a while. And if it does try to do that, that's an obvious breach of EU law. That should be an easy thing for a national court to decide. It should definitely have a review power to knock it down very easily if that were to happen. Now, finally, on the issue of reviews, I've already mentioned a link with the return process. There's a lot of issues, I think, which stem from that in practice that might have to be fleshed out. Maybe the amendment to the Returns Directive will do some of that fleshing out. There must be a joint appeal if the two things are integrally connected, the return and asylum decision. You must, if they're a single decision, there can only be a single appeal. If there's two simultaneous decisions, you can have two separate appeals, which of course is going to be awkward. You may have different judges, different courts, different court branches of the court system in that scenario. But there's some elements of dealing with a return decision, which of course is a different assessment. It's a non-refoulement issue in general, not necessarily an asylum issue that's being reviewed in relation to returns. And one thing the Asylum Pact does is in a whole series of places, it contains strict new rules, but says they're subject to non-refoulement as a standard, as a basic standard. But what does that mean? Well, I think people are often going to argue this, and national courts are faced with the question of determining exactly what it means and when to apply it. Because it doesn't necessarily mean you get refugee status. There would be maybe more people in future not getting or losing refugee status, but allowed to retain on a very limited basis on the basis of non-refoulement. Now, there will be time limits for appeals, both for applicants to bring them, very strict time limits, and the case law on strict time limits is a mess. I looked at it for the purposes of an article. It's not that simple, but the arguments could be that the time limits will be too strict, especially if we're talking the short ones between 5 and 10 days. Some of the existing case law of the Court of Justice is quite critical of asylum application time limits of member states that get into that level of acceleration. And even though it becomes an issue of set by EU law in future, it's still a potential challenge to it. Member states must now not only an option, an obligation to give deadlines to courts, directly affecting the work of the judges. But to repeat the point I made before, and here's a reference to the case, if you're unfamiliar with it, the time limits aren't really binding, according to the Court of Justice. And presumably, they aren't really binding, even though member states now have to give them, even though the previous legal context was different. It was an option. But what would be different now that it's an obligation? I don't think it becomes genuinely binding any more than it was before. Suspensive effect, slightly changed in various ways. Still a lot of exceptions. They now become mandatory, so there may be more issues and concerns about exactly how to interpret those exceptions from suspensive effect. Various other details change, so it's going to be quite relevant, I think, for judges often ruling on suspensive effect requests to determine whether those criteria are met. And some interesting and complex case law of the Court of Justice. Some might have to be reviewed or adapted because the rules on suspensive effect are different. Okay, so there are my contact details. In principle, we have 1 minute left for questions, but I'm happy to stay for longer if people can stay for longer and want to ask some questions. But thanks very much.
Thank you very much, Steve. I see already Andreina with a question, and although it is Friday afternoon, I do not want to deprive our audience of the privilege to have you on screen and be able to ask you a couple of questions. So, Andreina, I give you the floor.